Attorney Roger P. Foley, and I'm driving to the courthouse. Got a interesting situation that came up not too long ago, and that was I was hired by a client for a DUI case, possession of various narcotics. The facts were as follows. The individual was driving, according to the police report, speeding, doing about 20 miles an hour over the speed limit. The officer was doing radar, and he estimated the vehicle about 18 miles an hour over the speed limit, used his gun, and the defendant's vehicle was 20 miles per hour over the speed limit. He conducted a traffic stop. Now, upon stopping the defendant, he made some initial observations as he walked over to the vehicle. And those observations was he saw white on the top and bottom lip, which according to the police officer is a sign of someone who's smoking narcotics. The individual showed some signs of impairment and blurted out some information that they had recently been in an accident. The officer asked them to step out of the vehicle, and upon stepping out of the vehicle, they were unsteady on their feet, and their pupils were constricted, and a bunch of other basic observations that you would see with DUI. Now, the officer asked the defendant if he'd like to do exercises to dispel his belief that he was under the influence of drugs and or alcohol, and the suspect agreed. They began with the HGN. The officer started to give the exercises, the instructions to the HGN, which is please put your feet, together, heels and toes touching, like this, hands down by at your side, and I'm going to put a stimuli in front of you. I don't want you to move your head. And he's asking, do you understand? Do you understand? Now, while he's doing this, what happens? The defendant's smoking pipe, crack pipe, falls out of his pants onto the ground. Not a good start, right? Well, the officer notes it, keeps going, doesn't stop the exercise, doesn't make a big deal about it, even though right there he has him for paraphernalia and he can search, but he continues on with the exercises. The individual doesn't do great on the exercises, but doesn't do horrible. He's able to, he sways during the HGN, he sways during the one leg stand. He does the walk and turn, but he doesn't do it perfectly. There's some clues that the officer observes, and enough to ultimately arrest him for DUI. So the officer arrests him, does a search incident to arrest, finds one pill, then finds another pill, then finds some paraphernalia, then in a separate bag finds crack, cocaine, several rocks, finds Xanax, and the individual is arrested for all of these items. Now, I'm retained, I file in, and like I do on most cases, I reach out to the state attorney's office just to let them know that I'm representing the individual and I'd like to talk to them. Before I even have that conversation, I don't get to talk to them on the phone. And there's really not a lot that I can say, right? The stop is, first thing an attorney looks for, is the stop legit? Well, if the officer, again, his testimony, he's under oath, and he has a radar gun that's calibrated, he says that the person's doing 20 miles an hour over the limit, that's the reason for the stop's good. Now, the second part is the reasonable suspicion to begin the DUI investigation. In order for a police officer to begin a DUI investigation, he usually needs a combination of factors that he identifies. That could be slurred speech, slurred speech, or misappropriating his words or speaking lethargically. It could mean bloodshot, watery eyes. It could mean the odor of alcohol. It could be the odor of marijuana, right? If it's driving under the influence of marijuana. It could be nervousness. It could be shaking, even though those are not necessarily observations. They are observations or cues to the officer that something may be going wrong. So in this case, there were a couple of factors. They're kind of close on the line of whether or not they're sufficient to begin a DUI investigation. But considering the courts tend to lean towards the officers on this, I would say that if I filed the motion, the likelihood is it would probably be denied. More of the observations occurred once the individual exited the vehicle. So now the individual exits the vehicle. Well, if I could have done a motion on the stop or the reasonableness, then everything that came afterwards would go away. Problem is that this defendant made some statements about having an interaction with another individual, which was sort of outside the scope of the case. But he started making these statements that he just had an issue with somebody else. And so then, of course, the officer, had to check on his radio and call dispatch and say, hey, is there a victim? Is there another individual? Is there someone calling? This is the vicinity. And luckily, it turned out to not. The other person didn't report that incident to the police. So the officer does the exercises, does the search, finds all the drugs, arrests the individual. I call case filing, okay? Case filing drops the DUI. I have no idea why they dropped the DUI. Like, I'm looking at it, right? I'm a NHTSA instructor, and I'm going, I don't know. Stop looks good. It looks like there's reasonable suspicion. He gets out. He doesn't do well on the HGN. He shows all 6 signs of the HGN. He does the walk and turn, and he more than 2 clues. He does the one leg stand, same, more than two clues. So there's enough to arrest on the DUI. Whoa, what are people doing? So there's enough to arrest on the DUI, and I don't know why, right? As a defense attorney, I'm going, why'd they drop the DUI? Is the officer under suspension? I don't know. So the case is filed. I reach out to the prosecutor, and we end up speaking, I don't know, like the day before the court date, which isn't enough time to relay the offer and let a client meaningfully look over it. So the state gives me what I think is a really good offer for this charge, which is 1 year probation, a withhold of adjudication. That's pretty much like that's a good offer for all the drugs that they found, right? So I tell the client, here's the offer. He wants to think about it. I said, listen, let me get the discovery. Let me look for technical arguments. So I asked for the discovery, and the state attorney says to me, that's a pre-discovery offer. And I go, what does that mean? That means that I know you asked for discovery, but if I give you discovery, that offer will not be the offer. The offer will be an increased offer. And I'm going, that's kind of bullshit. What do you mean? Like, I have a constitutional right to see all the evidence against my client. My client, well, not I don't have the constitutional right. My client has the constitutional right to look at all the evidence that's against him and to do it. And the prosecutor's response is, yeah, they got that right. Well, actually, they don't really say that. They kind of ignore my question, but they go, look, if I give you the discovery, the offer's off the table, and the offer will be changed, and it won't be good for your client. Well, now, what does that do? That makes me think that they're hiding something. Are they hiding something? Has the officer been arrested? I don't know. Is there something in the video? I don't know. So I write back to the prosecutor and I go, hey, you know what? I don't know what this is, but listen, I've explained it to my client. He wants to accept the offer, but I don't know. I've not had this situation before, a pre-discovery, offer. I go, it seems like there might be some legal issues with it. And the prosecutor doesn't even respond. It's basically like, hey, take the 1 year offer or don't. If you want to do the discovery, we'll do that, but now your offer is probably going to jump to 2 years or 3 years or whatever. Is that right? I think that's the question. Is that right? A couple questions I would probably have if I was a client. What if I wouldn't have paid for an attorney? Would I have gotten the same offer? What did the attorney do for me, right? I mean, that would be my question. I just hired Mr. Foley, and he got an offer without doing, much fighting. That's a really good offer. Is he just so powerful? Probably not, guys. Does anyone care that I'm the attorney? Probably not, guys. Right? Other than they have to deal with my blah, 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 So I haven't researched it. I'm going to do some research. The client said, don't do anything. Don't take the discovery. Please accept the offer. Remember, I work for the client. But I have concerns, right? What if it turns out that, I don't know, the officer stole the drugs, or the officer was on drugs, or the officer's been arrested for something? What if one of those things? What if there was something incorrect in the police report? Like, I read the police report and go, oh, there's enough, but maybe the prosecutor knows that the officer copied and pasted from another police report. Well, I don't ever get to know that because I don't have all of the information. And if I don't have all of the information, I can't be as effective in fighting the case. So, I don't know. It's, I'm at the mercy of the client, right? Sometimes, if a client wants something, I'm obligated to do it. I got to do some research on this particular issue, but can you imagine having a case and your attorney doesn't get the discovery, right? I talk about all the discovery. I talk about taking depositions. None of this is able to be accomplished because this is a pre-discovery offer. No video, no audio, no CAD reports, no supplemental reports, no backup police reports, no body camera, no dash car camera. What the heck is going on? Why did the DUI get dismissed? And why did I get an offer that probably would usually be 2 to 3 years? What are these people doing? Sometimes I wish I was a cop just to do speed enforcement. That's why I don't do tickets. Too many people driving like idiots, doing 72. But what's going on? Why did I get this offer? Why didn't they want to give me discovery? Why did they drop the DUI? Conspiracy? Maybe I'm getting paranoid. But the client said, stop, I'll accept, I'm good. So I did. What do you guys think? Let me know. All right, I'm attorney Roger P. Foley. I'll talk to you soon. God bless you. Subscribe. See ya.